again, it depends on the nature of the matter. You start off with the premise that each party would be responsible for his or her or its own attorney's fees. And then once you start off with that premise, then you look to see if there are other ways that you could obtain attorney's fees from the other side. So if your attorney charges, can I recover those from the other side? One of the places to look is in the statute. You may be under a particular statutory provision that says that the prevailing party is entitled to attorney's fees. And right there you have it. So you don't need any other kind of contract or any other kind of document. You have the statute in place. You also have terms and contracts that will grant attorney fees to the prevailing party. One thing that oftentimes happens is that you will have one party that will draft a contract, and that attorney will put in there that if that particular party has to enforce the terms of the agreement, that the particular party that that attorney represents is entitled to attorney's fees, but it doesn't mention what happens if the other side wins. Well, in Florida, there's a theory that pretty much is explained by reciprocity, which means that if there is a provision that entitles a party to attorney's fees from the other side, if they're the prevailing party and is silent, if the other party is the prevailing party, the judge will grant attorney's fees to the party in which the attorney fee provision for prevailing parties is silent. So you can't just kind of have it one way. If it's in there for one party, then it's good for both parties. So those are two of the ways. There's also kind of a catch-all. In Florida statutes, it's 57-105 fees, which basically states that the complaint that was filed or the defense that was filed is so meritless that it kind of, in layman's terms, it's so far outside the ordinary things that a judge would see or the course of conduct or what a reasonable person would expect, either from the lawsuit being filed, that party, or from the person defending the action, that the judge should grant those fees even though there's no contractual right and even though there's no statutory right. Those are very, very difficult to get because it's a bad precedent. Because if you allow that, then really you kind of dilute down any kind of terms where you absolutely have to put in attorney's fees on both sides. They're on notice that if they lose, there'll be attorney's fees. So it does have a chilling effect to grant those types of fees, and it's not really good public policy. So most judges are very, very hesitant to grant that, but that is another way to collect fees in Florida.